Angry and heartbroken. Those are the feelings of a couple in Britain after their terminally ill daughter was taken off life support against their wishes, in a move that some say violated their parental rights. Welcome to EWTN News In-Depth. We begin today with a case that has made headlines around the world. 8-month-old Indi Gregory suffered from a rare metabolic disorder known as mitochondrial disease. Nicknamed their Mito Warrior, her parents fought to continue her treatment until earlier this week. Her doctor said her life support should be removed to allow her to die. Her parents, Dean and Claire, appealed this to the courts for a legal battle that included Italy's prime minister and the Vatican. Indi's parents pressed for the royal courts of justice to let them fly their daughter to Italy, where the Vatican's pediatric hospital, Bambino Gesù, offered to care for her. To do so, the Italian government even granted Indi citizenship. But the High Court sided with the hospital trust. A group supporting the family called Christian Concern says Indi Gregory died in the early hours of Monday, November 13th, after having her life support removed. Indi's father, Dean, released a statement writing, "Claire and I are angry, heartbroken, and ashamed. The NHS and the courts not only took away her chance to live a longer life, but they also took away Indi's dignity to pass away in the family home where she belonged." Indi Gregory's case is the latest in a series of cases in Britain in which doctors and parents have sparred over the treatment of terminally ill children. Alfie Evans in 2018 and Charlie Gard in 2017 were also ultimately denied the chance to travel to Italy by UK courts and died days after being removed from life support. Pope Francis has prayed for all of these cases. Following the death of Indi Gregory, the Catholic Bishops' Conference of England and Wales released a statement expressing sadness and prayers for the family. The conference also called for greater weight for parental voices in such cases, with a plea to reintroduce an amendment to British health law known as Charlie's Law, named after Charlie Gard. The amendment aims to prevent disagreements between parents and doctors from reaching the courts. Movement in British Parliament to pass Charlie's Law is slow. To discuss this case, we're joined now by Professor David Jones, the director of the Anscombe Bioethics Center in England, and Alex Schadenberg, executive director of the Euthanasia Prevention Coalition in Ontario, Canada. Gentlemen, thank you so much for joining us. Professor, I'd like to start with you. I think it's really important to bring it home for us who don't really understand the UK system. What allows this trust to do what it does, and how does the trust work?
So people sometimes think that this is an argument between a doctor and a parent about the child, but the doctor is just part of a large hospital, and the hospital itself might be part of a larger sort of structure, a bit like you might think like an insurance company in the States. And so you have this very large organization, and it's that organization that's making the decisions. It's the trust manager that's making the decisions. And if it goes to court, really the trust holds all the cards. They have much better resources. They have full-time lawyers, and they control how much medical information the parents get. And unfortunately, that means there's almost an incentive for the trust, if there is a disagreement, to go to court, because the trust thinks that it's likely to win if it goes to court. Whereas if they have to argue it out with the parents, it might take longer, and they just want to have a quick decision.
And it seems that the trust acts as if these children had no parents at all. Alex, talk to us about the situation in Canada. Is this similar as well there, with the issue of parents not really having access to the care of their children or those decisions?
Well, there's some similarities in the fact that we have a universal healthcare system. So once again, you'd be dealing in a similar case with a hospital, which has massive resources. The other thing that makes it very interesting is these are rare type of court cases. So therefore, you're dealing with the hospitals being able to hire lawyers who this is all they do, whereas families are really, hiring lawyers who have really very little experience in this area. So it's really a David and Goliath situation every time. We have had some similar cases in Ontario, such as we had the Baby Joseph case a few years ago, which was very similar to these cases, and a little bit different, though, with the result. Nonetheless, this is a universal problem.
Absolutely. Now, Professor Jones, it seems we've had these cases over and over and over again. What do we need to learn from these tragedies?
Well, I think that in England the law needs to change, and there's a palliative care doctor who's also a member of the House of Lords, our upper chamber, and she introduced an amendment to the law, which I think would have been really helpful. And what it would have done is it would have just slowed the process down and required the trust to do various things before it went to court, including sharing information with the parents, including allowing other doctors to have information about about treatment, and the trust would have to show that there was actually harm involved if they went with what the parents wanted to do. At the moment, it's simply if there's a dispute, you can go to court, and as soon as you get to court, then the judge just makes an independent decision. So what we need to do in England, I think, is we need to look at the law.
Right, and that's the Charlie Gard law. Well, how then is this case, though, different? Was it different?
Depressingly, not very different. I mean, I think we haven't learned. I mean, we should have learned from Charlie Gard, and we should have learned from Alfie Evans and from Alta Fixler and from Pippa Knight. I mean, we've had these cases over and over. Sometimes, as with Charlie Gard, sometimes there's a novel therapy that you might want to try. Other times, it's not really about an alternative therapy. You just want to have more time and see how the child, whether she gets better, whether she gets worse, just to see how things would go naturally without thinking, well, let's withdraw treatment and then we know how things will go.
Right, for parents to really be able to have that in their hands. Alex, you've seen a troubling conflation of the issue of euthanasia with these cases, and I say troubling because it means that the public is missing something very important about the role of powerful governments or powerful institutions here. Clarify that for us, please.
Well, these cases are very upsetting and emotional, but they're not euthanasia when you actually withdraw treatment from someone and they die a natural death, because euthanasia is actually about doing an action to cause death or a specific omission, which would be like a basic care, such as dehydrating someone to death or something like that, which would be the intention to cause death. In this case, the child died a natural death, even though the circumstances, of course, are the issue at hand. And that there's a difference. There's a clear difference between killing and letting die. And this is where we see that clear difference in these cases. Not to say that what happened to the baby was, in my opinion, acceptable, but it's not euthanasia.
Right. It's the denial of life-saving treatment and the removal of life-sustaining care. Both very, very important
who makes
differences.
The decision? Because the judge has made the decision that the parents did not have the right to move the child to another hospital. In this case, of course, out of the country. It would have been in Rome. Nonetheless, it's usurping the right of the parents to try and make the best decision when they love their child. Like it's totally different than in a case of abuse. This is parents who love their child who are trying to make the best decision for their child who's very sick.
Absolutely. Well, the idea of traveling, though, Professor Jones, is something that I'd love for you to kind of wrap up for us. You can travel anywhere you want to end your life. You can go have a customized experience in a pod, but you can't leave for life-saving treatment. Where is the logic in that?
So it's not about the fact that you can go to have assisted suicide in Switzerland, but you can't go for treatment somewhere. If you're an adult, you can. The problem is, if you have a child, it's like a custody battle. Except instead of between two of the parents, it's between the parents and the hospital, and the judge comes down in favour of the hospital. So the judge decides what the judge thinks is the best for the child, and then that's the decision. What it should be is, are the parents being reasonable? Are they harming the child? If they're not obviously harming the child, then it should remain in their hands, and that's not where we are with the law in England at the moment.
And it's a scary influence that it might have on the rest of the world. Last question for you, Alex, just to wrap up. In Canada, Quebec, that province is particularly notorious for the way that it uses and implements euthanasia, especially with the elderly. What are the points of pain that we should be watching around the world on this issue?
Well, in Canada, when we removed the terminal illness requirement, now, first of all, obviously, I'm opposed to killing people, so I'm opposed to all euthanasia. But when it went totally crazy is when we removed the terminal illness requirement. And now you have a situation of people who have disabilities. They qualify for euthanasia based on their disability, but they're asking for it based on poverty or homelessness or an inability to get medical treatment. And there's many other, social reasons why they're asking to die. So you see now that Quebec has become the highest euthanasia rate in the world, and it's gone really out of control. I'm very concerned because we're very early into this in Canada. It was only legalized in 2016. What I can say to the world is don't legalize euthanasia. Don't ever do that. And the reason is that you can't really control it. And I'll give you one prime reason. All the restrictions they put into the original law, which I thought were just, ink on paper anyway. Nonetheless, all those restrictions that have been torn down based on this concept of equality. You can't deny something to somebody else. That's why they got rid of the terminal illness requirement. They said it was unequal. When you deny this to someone who's not terminally ill, it was an unequal access to I would just say, a legal situation. So and that's how the courts dealt with it, and that's how Canada's dealt with it. So equality ends up getting rid of your protections in law.
That's right, and it allows the government full control. Well, thank you, gentlemen. I really appreciate your time on this.